Swayam Prabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my fourth lecture in the series of this CPC, Civil Procedure Code 1908. So, today I will discuss this one, order 32 of CPC. This is particular type of suit, and after this also I will discuss order 33. So, this is order 32, suit by or against minor and person of unsound mind. So, this is very important topic, because sometimes we get confused, like if we are minor, I mean if plaintiff is minor or defendant is minor, then who will file suit and how court will entertain, or whether court will entertain I mean them or not, because they are not mentally, so far as the position is concerned, this thing, they are not mentally stable one, or they do not understand the things, they are not competent one, minor, a person who has not attained the age of 18 years. So, I mean he may be competent, but law does not consider, because he cannot, sometimes children are good enough even at the age of 12 or 13 or 14 years, they can understand the questions, they can understand the things, but law does not recognize. Law say no, there is a need of some assistance, there is a need of some help to them, otherwise without the appointment of guardian or without the appointment of next friend, there should not be any suit. So, this is what we have to discuss here in order 32 of CPC. So, you will also understand in first slide of this one, this order 32, there are 16 rule, this pertains to lawsuits involving minor individuals with mental incapacity. See this one, this mental incapacity, it means mental incapacity does not mean that they do not understand, they cannot protect their right actually. I mean law consider them no, they are still, I mean they are minor, they are person of unsound mind, so they need help. Mentally they are stable so far as minor is concerned, but unsound mind, the position is vice versa, because they are definitely, with the word itself you can come to know, person of unsound mind, it means he is not getting, or he cannot protect his or her own interest. But so far as minor is concerned, who has not attained the age of 18 years. So, this is what we have to discuss here. So, mental incapacity you have to club with this meaning. So, this section outline the prescribed procedure for initiating. So, this basically this order prescribing a specific procedure for initiating lawful suits involving minor and individuals of unsound mind. So, historically legal system often assumed that, I will just read it out, and if I get something new, so then I will let you know. So, legal system often assumed that minor and mentally incapacitated individuals lacked the capacity to initiate legal proceeding due to their perceived inability to reason and understand legal matters. This is one, because they do not understand, they do not have reason, or they do not understand legal matters. The legal matters are serious one, you have to answer, you have to stand before the court, So, you have to answer all the questions what is asked by the honorable court. So, that is the reason you cannot understand, there is a proper procedure, there is I mean seriousness must be there. A minor, I mean we cannot expect everything from a minor, we cannot expect this kind of seriousness from a minor, whatever is answering that would be whether logical or not. Sometimes just because of innocence, they have innocence, a minor has innocence, a person of unsound mind does not understand the importance of these legal matters. So, these are the things. So, you cannot expect reason. So, that is the reason section 1118, section 118 of Indian Evidence Act also talks about competent witness, whether minor is a competent witness or not. So, I already told you, even child at the age of 12 years, he can be competent, but you cannot expect them that kind of seriousness, that kind of reasoning from them, that kind of answer what is asked by the court, whether that would be really relevant one or not. In innocence, minor can answer vaguely, sometimes you can compare, I mean you can imagine the position of 12-year or 13-year or 14-year child, how he answers, innocently he answers, innocently, I mean he does not take the thing seriously. So, all these things are there with the child who is of below the age of 18 years, or a person of unsound mind. A person of unsound mind, the position is absolutely different. He always takes things guaranteed. He always because he needs love, affection, and he does not take the matters very he cannot take the matter very seriously. So, this is with the mental faculty of that person of unsound mind. So, this is what. So, reasoning and due to understanding of legal matters. So, they need help. However, it is gradually becoming apparent that there was a need for legal provision to safeguard the interest of such individual. So, without this you cannot, if there is no legal provision, although section 11, this is also one more thing apart from the section 118 of Indian Evidence Act, ki whether child is a competent witness or not. Section 11 of your Contract Act 1872, this is also important provision. Section 11 basically will tell you ki whether a minor can enter into a contract or not, or the contract what is entered by a minor is void ab initio, because he just because of this reason itself, because he does not have reasoning, or he does not have reasoning as well as understanding of legal matters. So, that is the reason Contract Act only is a substantive law, but we need procedure. This is because here in CPC we talk how he file suit, although because the matter can be by or against the minor, the matter can be by or against the person of unsound mind. He can sue or he can be sued. So, this is the thing, from both the angles we have to understand. Suppose he does not want to file, but somebody is filing, suppose against the minor, then also he needs the appointment of guardian and next friend. For minor plaintiff, we need next friend. Keep these two words in mind. For minor plaintiff, we need next friend, and for minor defendant, we need guardian. So, this is the difference between next friend and guardian also. I will let you know further. So, Order 32 was specially enacted to protect the right and interest of minor and individual of unsound mind, ensuring that proper representation in civil matters and legal proceeding, and that can be ensured only through the appointment of next friend and guardian. So, this is the Order 32 of CPC, suit by or against minor and person of unsound mind. So, let me take you on second slide. So, this is the definition of minor and person of unsound mind. Minor, as per section 3, see this one, as per section 3 of the Majority Act of 1875, a minor is a person who has not attained a majority, that is, who has not attained the age of 18 years. But in the case of minor for whose person or property a guardian is appointed by the court, or whose property is under the superintendence of the court of what, the age of attaining majority is 21 years. So, this is the difference ki in what case you need 18 years or in what case you need 21 years. So, 18 years basically you have to understand ki a person as per Majority Act, ki a person who has not attained the age of 18 years. So, this is the definition, and for in case of appointment of guardian 21 years you have to consider. Unsound mind, as per section 12 of the Indian Contract Act, a person of sound mind is a person who is capable of understanding and forming a rational judgment as to its effect on his or her interest. Understanding, person of unsound mind means ki who is a sound mind, means ki sound mind who can understand the question, who can understand the legal proceeding, who can understand the court working, that is called a person of unsound mind. So, similarly, this is applicable in case of minor also. A minor cannot be, you cannot expect that kind of soundness from a minor. So, here in case of, because this is what unsound mind person. So, basically telling ki who is sound mind, ki who can understand the question, who can understand the legal proceeding, who can understand the court working. So, only to that person you will call ki the person is of sound mind. If he is not understanding, because court cannot take it, you cannot take this proceeding lightly, okay, whatever you want you can answer that thing and whether that is relevant or not. So, this is also one thing. Similarly, in section 84 of the Indian Penal Code 1860, a person of unsound mind is a person who by reason of unsoundness of mind is not able to know the nature and consequences of her act. This is also whether it is right or wrong. So, Indian Penal Code is also defining this one ki who is a person of unsound mind, who just because of his who is not understanding the nature and consequences ki whatever he is saying, whether this is right or wrong, whether this is reasonable one or not, relevant one or not. So, person of unsound mind ask very sometime irreasonable or irrelevant question, or something which is very vague one, something what the person who is standing before him cannot, he cannot understand the thing, what he want to say, what he want actually. If you have seen somebody person who is of unsound mind, so then you can imagine the position of unsound mind. He does not know whether he is hungry or not, he does not know whether he is thirsty or not, he does not know, just by gestures he try to show this thing okay what he needs, and try to convey his ideas, or try to convey his the thing what he really want. But he cannot express the thing in the manner what a person of sound mind is expressing, how a person of sound mind is expressing. So, this is the thing. So, this is the reason we need the protection, legal protection. So, that is the reason we have kept this order 32 of CPC here in order 32 in CPC, yes, through these provisions now you need protection, and you can get appoint your next friend as well as guardian as per the case, as per the need of the case. And there is the importance of this order 32 of CPC. Without it, you cannot protect interest. In order 7 rule 1, I already told you yesterday also, I was telling you my first or second lecture, order 7 rule 1 plaint defines basically ki if you are a minor, you must clearly mention this thing. There are 11 or 12 clauses are there in rule 1 of order 7. If you are minor, you should state this thing, you should bring this thing in the notice of the court, you should mention it specifically in your plaint. Okay, the person is a minor person, the person who is filing is a minor person, or the person against whom he is filing suit is a minor person. This kind of thing, whether plaintiff is minor, or if plaintiff is mentioning, so he must, that is the reason there is a in first or second part of your plaint, you will write it. Okay, plaintiff name, age, and name, age, and address. Defendant name, age, and address. So, this is the relevance of this age. With this age, okay, if you are mentioning okay, you are 14 year or 16 year or 15 year, and apart from it also, otherwise, if the plaintiff is minor, then you should specifically mention in your plaint. You should draft your plaint in such a way that okay, court would come to know after reading your plaint that the plaintiff, the person who is standing before him, is a plaintiff, or the person against whom the matter is being filed is a minor one, is a person of unsound mind, because this becomes the duty of the court. This becomes the duty of the court to know this thing, to protect the interest of the minor, to protect the interest of the person of unsound mind. You cannot take the things, everything guaranteed one okay, whosoever is there just neutrally you have to decide, okay, no. But here you have to, after reading plaint, court must understand this one. And suppose if otherwise you people, being an advocate, you people, you should bring this thing in the knowledge of the court the plaintiff is minor, the person is, the defendant is minor, the person is of unsound mind, the person is person of unsound mind. So, only then court would take due course, or court would adopt the right procedure, and court will. So, order 32 is for the protection. So, I already told you section 1180 of Indian Evidence Act also you must read. With this order section 11 of your Contract Act also you should read. The position of minor in Contract Act, what is the position? Apart from it, in Partnership Act also section I think 32 talks about it whether minor can be a partner or not. So, these provisions you should club together, and you should read collectively. Then read it okay, what is the position of minor. If you understand the position of minor, then you will understand okay, when Contract Act is also giving space to minor, Partnership Act is also giving space to minor, then this through this procedure you can practically apply, you can file your suit. So, this is what I wanted to tell you. So, this is my second slide, and third one, order 32 rule 1, we will go one by one, one by one each rule. So, order 32 rule 1, minor to sue by next friend, this is what I was telling you, minor to sue by next friend. Rule 1 of order 32 provides that every suit shall be instituted in the name of the minor by the next friend, in the name of the minor by the next friend of the minor, and the next friend is any person who has attained majority. Who will be next friend? For minor plaintiff, you need appointment of next friend. And now the question also arises who will represent, who will be next friend? So, this what this rule is answering, rule 1, ki next friend is any person who has attained majority is or in some way related to the minor as to ascertain his or her interest. The next friend will act on behalf of the minor in suit or proceeding before the court and is a bona fide manner represent his or her interest. Ki next friend must be must be major one, must be a person of sound mind, and he must represent in a bona fide manner in all legal proceeding. He cannot take the matter of minor lightly. So, this is in the case of there is one case also Melabati Tea Estate versus where a minor workman makes a claim under some provision of the Industrial Dispute Act, he has to be represented by an officer of the trade union as per section 36. This is specific one, otherwise here also next friend can be the court officer. So, here in case of Industrial Dispute Act there must be an officer of the trade union, and this provision has been kept just for the protection of the, because we have to see before appointing the next friend, we have to see this thing, court has to see this thing. Consider this one, ki who is representing the minor interest, whether this next friend is good one or not, is a bona fide person or not, whether this person, because this is very crucial one. Otherwise, there are number of persons who will come, because this comes through sometimes court invites the application ki who want to become my next friend. If there is no one, then court will appoint any officer of the court also. But if you through legal through newspaper, vernacular newspaper, if you appoint or if you ask the name of any next friend, then anyone even your relative can come forward or any stranger can come forward ki no I want to become the next friend, I'll work bona fidely. So, then automatically Buaji and Chachaji will come, kind of people will come and they will show ki we love these children, and this kind of thing comes, why we need. Again you have to understand, because I have seen personally all these things. So, like in insurance matter when there is a claim, good kind of compensation, good kind of amount, insurance amount is there, then automatically everybody from relations will come ahead before the court, no we want to protect the interest, we want to become the next friend. This is the thing what you have to see, consider how serious this can be, the position of next friend or the interest of minor, how this can be serious. Because court has to appoint, and court will appoint on the basis, but you cannot see anybody from inside what is happening or what is running in the mind of the next friend. So, that is the reason, because it is a question of money, it is a question of insurance amount, it is a question of claim and compensation kind of things. So, then we need, otherwise also in other kind of matter also. So, people will become try to become familiar. So, that is the thing. So, in the case of state of Rajasthan versus RD Singh, it was held that a minor suing through one next friend cannot sue through another next friend in another case, nor can she for the same cause after attaining majority. However, the court is empowered to appoint a next friend during the pendency of the suit. That is a different thing. During the pendency also court can appoint another next friend. This is when your next friend is not working properly, then court has very much power, because this happens, next friend is appointed with the permission of the court only. With the permission of the court. So, I will let you know in further slides. Rule 2, suit without the next friend. Rule 2, in this case the defendant can apply for the plaint to be taken off the file by merely showing that the plaintiff is a minor and that suit was filed without a next friend. So, this is, suppose you file any suit being a minor plaintiff, then this becomes the duty of the defendant also. He will say no the plaintiff is minor, because he know this thing, or defendant advocate or defendant personally must know this thing ki against who who has raised allegation against who is the plaintiff in this case. If the plaintiff is minor, so without appointment of next friend, the defendant should not proceed further. The defendant should bring in the knowledge of the court ki no the plaintiff is minor, your lordship kindly appoint first next friend in this case. So, this becomes the duty, because I already number of times in civil matters I tell you ki this is your case, the case of advocates, the case of concerned parties. So, they must be aware about their right. You cannot say subsequently ki no by mistaken or this and that happened. You cannot be lazy one or passive one. When the proceedings are going on or when the matter is there before the court, so you should be aware about all those things, what is happening in your case. And immediately if you have any objection, you should raise that objection before the court, and court will appreciate it. So, either the fact of the minority is apparent on the face of the plaint, apparent, if it is apparent, then there is no problem on the plaintiff, if the court is coming to know that minor is plaintiff, then there is no problem. It is ascertained by the objection raised by the defendant. I already told you the objection must be raised by the defendant and the inquiry by the court, then court will conduct the inquiry. If you raise objection ki minor is, this minor is, plaintiff is minor one, then you should raise objection and court will conduct the inquiry. Although age is there, but sometimes you, it happens if you do not have age certificate. So, then also this kind of problem can come, then through the advocates or through the inquiry, court will come to know this thing, or court will conduct inquiry in this case. So, in the case where the minor has no such knowledge or intention to deceive the court, the practice is to provide sufficient time to the minor to enable him or her to be represented by the next friend. Sometimes this can also happen ki you being a plaintiff, although you are minor, but you are plaintiff, but just because of this innocence, if you do not understand or if you have not heard about order 32 of CPC, then you commit this kind of mistake. So, then sufficient time can be given to by the court to you, get appointed first next friend. You can also suggest some name, your advocate specifically can suggest some name, or the court can also suggest some name, because it basically a question of the question of next friend and the relation of minor is concerned so far as. So, it also comes through love and affection ki if the child is saying ki no I am familiar and he is my really he loves me, this chacha ji or bua ji or mama ji or mami ji, if they really loves me. So, then also there is no problem, court can ask this question from the court, because ultimately what is this? Hindu Adoption and Maintenance Act, section 12. Section 12, welfare of the child is paramount consideration. This is the thing what you have to understand, and court also keep this thing in mind. Welfare of child is the paramount consideration, and court will give importance to this word welfare, ki how the welfare of the child is protected, how the child is protected properly, whether there is a welfare in this particular appointment of next friend or guardian is or not. So, court will take into account this thing. If the welfare is not there, if the next friend does not work properly or guardian does not work properly, then in that case court has very much power to remove the guardian or to remove the next friend. Court will take into account, court will conduct inquiry, court will in advance understand this one, ki who will protect the interest of minor, whether there is a welfare in this particular case or not. So, because welfare of the child is paramount consideration, and there can be no compromise with this word. There can be no compromise. Normally in my classes also I suggest one movie of Ajay Devgan, Main Aisa Hi Hoon, Ajay Devgan old movie, where he was mentally disabled one, and he needs the custody of his own daughter, but the court said ki no you cannot protect the interest of this baby girl. She was around 13 or 12 or 13-year old in that movie, and you must watch that movie ki what is the welfare of the child. Then in that case Susmita Sen was the lawyer, and how she protected the interest and how the thing happened in that case. So, you must relate that movie with this order 32 ki what is the welfare of the child, what is the interest of minor, what is the role of next friend, what is the role of guardian. Otherwise court will not give custody, otherwise court will not appoint you. So, this is also one of the things. Even in this movie the custody was not given to his own father, Main Aisa Hi Hoon, because there was a clash of interest. She was 12 or 13-year old girl baby, and the father was mentally disabled one, mentally a person of unsound mind. So, because welfare of the child is paramount consideration, this is what I am telling you, although this is not directly, but there is a, you will understand little bit about it, ki what is the role of this, what is welfare actually, welfare of the child, what is the role of, importance of custody, what is the role of, next friend and guardian. So, this is one thing. So, payment of cost, when the suit is instituted by a minor without a next friend, the pleader or the person presenting the plaint is liable to pay the cost associated with that suit. Instituted by a minor without a next friend, the pleader or the person presenting the plaint representing the plaintiff is liable to pay the cost associated with cost subsequently. What would be the consequence or what would be the result of the case? So, I mean you know this thing, because if you file your suit and the defendant comes, and if this thing, the thing does not come in the in the knowledge of the court, then who will suffer finally? Court will say no, you got the decree against a minor. I mean who couldn't. So, how would you say that the court I mean he was represented or got the opportunity of this one audio partem. So, there must be, both the parties must be competent who are representing their case before the court. But if you are a minor, then how would you ensure this kind of fairness? So, this is one thing. Rule 2a, security to be furnished by the next friend. This is also important thing. Security to be furnished. Rule 2a under order 32 stipulates that when a minor initiates a lawsuit with the assistance of their next friend, the court has the authority to require the next friend to provide security for covering all the incurred cost or anticipated cost at any phase of the lawful lawsuits. So, court can demand even security amount also from the next friend. This provision is designed to discourage baseless or frivolous, just to discourage this kind of baseless or frivolous litigation. If you are without next friend or you are filing your matter through next friend, I mean if you have objection, because this is court will take into account whether next friend is right one or not. But suppose you are coming through next friend, already you know this procedure, advocate is suggesting you through next friend you should file your suit. So, sometimes this can be baseless also, the case can be baseless also, the case can be frivolous one also. So, just to discourage this one, court can, if the court feel no this, I mean if the court gets any doubt, then court can demand any security amount also from the next friend. So, because this is just to discourage the baseless or frivolous litigation undertaken by the next friend on behalf of the minor. On behalf of the minor, see this line, on behalf of the minor, if next friend is filing any suit on behalf of the minor. So, that can be frivolous or baseless. So, in those cases, but that varies case to case also. If the court feels there is a need of security amount, then court can demand it, otherwise I mean it is up to the court. Rule 3, guardian to be appointed for the minor defendant. Guardian, I already told you the difference between next friend and guardian. Next friend for minor plaintiff and guardian for minor defendant. The court play the role of locus parentis, is the place of parent for their citizen who are unable to protect their rights and interests due to some infirmity or lack of adulthood. This rule mandates the court to delve into the question of minority or unsoundness of mind of the person defending the suit, and upon such satisfaction, appoint a proper person as a guardian ad litem, guardian for the suit for the minor defendant. See this one, minor defendant, there is a need of appointment of guardian, and court will take into account this one whether the interest of minor defendant is protected or not. So, if there is no minor defendant is there, then court will appoint. The appointed guardian will represent the minor defendant throughout the whole litigation, but is not a party to the suit, or that is a I mean simple thing, because he is just representing. And there are two cases also. So, you can go through these cases and we will come to know all these things about it. Rule 3a, decree against minor not to be set aside unless prejudice has been caused to his interest. This is very important rule again, rule 3a. This rule establishes a requirement that the court should not annul any decree issued against the minor solely on the ground that the next friend or the guardian holds a conflicting interest in the subject matter of the lawful suit. It is essential to demonstrate that the conflicting interest of the next friend or guardian has resulted in harm to the minor interest. This is the thing, resulted in harm. So, I already told you that welfare of the child is paramount consideration, welfare of the child. So, court will take into account, I mean this cannot be the sole criteria of rejecting or I mean setting aside the decree. There was a conflict of interest between minor and next friend, or guardian and defendant. If it is not harming the interest of the minor, there can be difference of opinion, or there can be kind of conflict. But if it is not harming, if the child interest is not anyway I mean is not at stake, then there is no problem. Court will move further, court will proceed further. So, basically the interest, minor interest, that is welfare, again I am repeating it, that is welfare of the child, welfare of child, what we have to see here in this case. And under order 32 of C. Welfare of child is important. So, this is the thing what you have to. Nevertheless, the minor retains the right to seek legal remedies against the next friend or guardian responsible for harming their interest. Oh, that is a different thing. Otherwise, also he has other kind of remedies. So, rule 4, who may act as next friend or be appointed guardian for this suit? Who may act? This is again, I mean, rule 4 will tell you who can be next friend or who can be guardian. Guardian appointed by the competent authority, where a person is declared or appointed by the competent authority as a next friend or guardian, only that person who is so declared is eligible to appointed. In the case of this one, a guardian appointed by the Hindu father in his will for his minor son was not a guardian appointed by the competent authority within the meaning. This is also, agar if you appoint somebody in your will, that is not the ultimate thing, that is not the, but that is not the guardian appointed by the competent authority. Court will see from his own interest, I mean from his own from its own side, whether the person is fit for becoming a guardian or not, fit for becoming a next friend or not, because court is the competent authority, court is the matter is before the court and court has to decide this one. Anybody cannot be the guardian, because who knows, suppose somebody today somebody is your friend and tomorrow whether he will be your friend or not, who knows this thing. Today somebody is your well-wisher, tomorrow whether he will be your well-wisher or not, whether he will be well-wisher of the child or not, who knows this thing. So, that is the reason court consider as per the case before the time, I mean that at the particular time when the matter is coming before the court, whether this is fit person to be appointed as guardian, whether this is fit person to be appointed as next friend or not. So, these are few things. Officer of the court as guardian, this is also very important. Rule 4, provide that no one is fit or willing to act as a guardian. Ad litem, the court can appoint any of its officer as guardian. Court can appoint. This is this. I mean, normally court appoints if there is no one or nobody is fit. I mean, who is coming with the plaint or who is coming through the will. So, if he is not fit and willing to act as the guardian, then court can appoint any of its officer. In doing so, the court must satisfy itself that such a person is fit for such an appointment and is the proper person to protect the interests of the minor. In such a case, the court may direct the cost incurred by the officer to be borne by the parties to the suit out of the court's fund or out of the minor's property. So, definitely court will keep some or will order some remuneration for this work, I mean for the work of this next friend and guardian. So, court will keep all these things also. I mean in the order itself court will mention he will get this much or this can be out of the court fund or out of the minor's property also. So, but court must inquire this thing, must satisfy itself whether such person is fit for the appointment or not. Appointment means appointment of guardian, appointment of next friend. So, this is what any officer. So, normally this opportunity is given to young lawyers, because those young lawyers who was really serious one, those young lawyers who was really appearing, who are appearing daily before the court and upon whom the court has trust. So, court normally demands from the senior lawyers, okay, anybody. So, this is what how you have to understand the importance or the meaning of order 32. So, rule 5, representation of minor by next friend or guardian. This rule provides that every application except the application for a stay or proceeding after the removal of the next friend or the guardian ad litem under sub rule 2 of this one made to the court on behalf of the minor should be made by the next friend or the guardian ad litem. Rule 2, the case where the minor is not represented by the next friend or the guardian ad litem, in this case the court may discharge the order which anyway affect the minor in any event. Moreover, the pleader at whose instance such an order was passed, provided that he knew about the fact of the minority of the minor plaintiff, will furnish the cost to be paid by the court. So, this is very simple one, how representation of minor by next friend or guardian for the suit will take place. So, rule 6, I am just emphasizing on those rules which are really of some essence. So, receipt by next friend or guardian for the suit of property under the decree for minor. So, rule 1 specifically specifies that the next friend or the guardian ad litem should not receive any movable property. This is also one thing, should not receive any movable property or money on behalf of the minor except with the leave of the court. This is the thing, minor, this one, next friend or guardian cannot do anything without the permission of the court. they cannot say subsequently, I mean they cannot receive any movable property or any money on behalf of the minor without the permission. If they need any kind of transaction, although this can be in the for the interest of the minor, but for that also they have to file application before the court and they have to get permission from the court. Okay, I am going to do this thing and this is for the interest of the minor, I am going to receive this, accept this movable property or money on behalf of the minor. So, all those transactions, all those things, this is absolutely the work or the job of next friend or guardian is absolutely under the scrutiny of the court. Without permission, for every work they need permission. If they want to spend anything for the for minor, then also they need permission, because it's a question of minor welfare, it's a question of minor interest. Who knows whether this is for minor interest or not if there is no permission. So, that is the reason, I mean there is a specific rule for this one. It could be either by way of compromise order, I mean compromise order also can take place, I mean on behalf of the minor with the opposite party, or through a order or decree of the court in favor of the minor. The provision seeks to protect the asset of the minor in the suit. This is already told you, insurance amount, compensation, or money compensation or insurance kind of claims, all those things, or otherwise also assets of the minor who has been left by alone by their parents. I mean if something wrong happens with them, so if they are alone, so then the assets of the minor. So, just to protect this thing, this provision is there in order 32 of CPC, that is rule 6. However, this rule is limited to money or movable property in the case of Sharda Prasad versus Jamuna Prasad, where the order was for the delivery of possession of the immovable property. This rule would not apply. In sub rule 2 of this rule, it is provided that where the next friend or the guardian ad litem was not appointed by the, but basically I will say you should go by the provision of CPC. Instead of, because there are number of judgments and every judgment is saying some judgments I mean in that way or some judgment in other way. So, you should go, first of all you should read the basic provisions, the bare language of your order 32 CPC, then you can relate it with the judgments. Rule 7, agreement or compromise by next friend or guardian, application for grant of leave from the court. According to rule this one, in order to get a grant of leave from the court, the next friend or guardian is required to apply for the leave of the court. Such an application should be supplemented with the affidavit of the next friend or guardian. This is also with the application, if you need permission, then that must be supported by an affidavit of minor, affidavit of that next friend or guardian, because that is a substantive piece of affidavit. So, that is a substantive piece of evidence. So, further it is there. It provides that following steps to be taken before entering into a compromise. This is important one. Application for the leave of the court, affidavit showing that the compromise is for the benefit of the minor. This is one thing, I mean you must understand this thing, for I mean if you need permission of the court. So, and with the affidavit that in affidavit you have to mention ki compromise is for the benefit. If you are entering into any compromise on behalf of the minor or for the minor, then you need, I mean application, because you need permission from the court, and that must be supported by an affidavit. And third one, certificate by the pleader in the case of minor represented by a pleader that the agreement or compromise is for the benefit of the minor. Court guaranteeing the leave if it thinks fit. Court will grant leave when court will think okay, this is really good one and this is good for the minor. Consent of the next friend or guardian to the proposed agreement or compromise. Consent is equally important. So, this is what how agreement or compromise by next friend will take place. This is section rule 8 to 11 talks about retirement, removal and death of next friend. If I mean how they would retire or what is the procedure of removal of next friend, something this can sometimes this can also happen in between of the proceeding, during the proceedings, if the minor next friend is not working properly or the guardian is not working properly, or in case of their death, what would be the position of, I mean who will take care who will take care of the minor interest. So, this is what we have to think. So, order order instead of order we will say ki this is order 8, or this is we will say this is rule. This is rule 8 retirement of next friend, and rule 9 removal of next friend. So, rule 9 provides that the circumstances in which the next friend can be removed by the application made on behalf of the minor by the defendant or by the guardian. So, in case of Shyam Singh versus Jaswant Singh, it was stated by the Punjab and Haryana High Court that principle behind such removal is to safeguard and not prejudice the interest of minor, welfare of the child. Again, I am repeating, and in this judgment also you will find the same thing, ki interest of the minor, ki why we remove next friend, why we remove, the court remove guardian, because just to protect the, just to safeguard the interest of the minor or the interest of the minor. So, rule 10, this rule is attracted, I mean only when the death of the next friend is brought to the notice of the court, and where it is not done so and appeal was heard in the ignorance of such a fact, the decree passed is not a nullity. So, this is all about, I mean in this particular case, this in I mean in case of death what would be the position, ki only when the death of the next friend is brought to the notice of the court, and where it is not done so and appeal was heard in the ignorance of such a fact, the decree passed is not a nullity. Sometimes, I mean basically the interest of the minor is important. So, you cannot say this thing, okay, if this thing does not come in the knowledge of the court, then the entire proceeding what has already taken place is useless or worthless. No, no, there is a meaning of this thing, there is the importance of this thing, court will not set aside all those things. So, this is one thing. Rule 11, retirement, removal and death of guardian of the suit. Rule 12 to 13, minor attaining majority. So, after attaining majority, what would be the position of minor? After attaining majority, what would be the position of minor? This is what is being dealt by rule 12 and 13. After attaining majority, suppose during the proceeding the minor gets majority. So, this is all about this one. So, when during the pendency of the suit or appeal on behalf of the minor has attained majority, the court comes under the obligation to call for the minor and ascertain his or her wish as to whether to proceed further with the suit or appeal or not. So, this is also after, suppose minor gets majority during the proceeding of the case, then in that case also court will, I mean the court comes under the obligation to call for the minor. Court can ask from the minor himself or herself whether you want to proceed with the suit or not. So, this is the thing, and he will answer all these things, whether you want to proceed with the suit means whether really you want to continue with this next friend, whether really you want to continue with this guardian, because this is for again for the, because now he has become major. Now he has become major. So, that is the reason court gives this opportunity to the minor, because now if he has attained the age of 18 years or if he has become a person of sound mind, then court can give this opportunity, okay, now you can, if you want to continue on and on, then also there is no problem, because ultimately this is your case. We appointed guardian, we appointed next friend just for the sake of your interest, but now you are in that position, you have come in that position, you can protect your interest on and on, because you can take your decision decision can be reasoned one, your approach can be reasoned one. So, you can continue with your case on and get removed this next friend or guardian. So, this is the thing what I am telling you, this rule 12 is telling you. So, in case of a minor co-plaintiff attaining majority, rule 13 provides that where a minor co-plaintiff attains a majority, question of co-plaintiff and co-defendant I already told you. So, attains a majority and desires to repudiate the suit, the court may dismiss him from the suit as it think he is not a necessary party to the suit. If co-plaintiff attains majority, not minor, co-plaintiff, not the minor plaintiff, this is about co-plaintiff, then court may dismiss, depends on case basically. The notice of such dismissal should be provided to the next friend, co-plaintiff in the suit or to the defendant. Moreover, the court may direct the party to pay all the cost incurred during such proceeding. For this, the co-plaintiff has to make an application to strike out his name. This is simple procedure, strike out his name from the suit, but if the court think he is a necessary party to the suit, it may direct the party to be made a defendant. It may direct the party to be made a defendant. So, this is all about procedure. Okay, if co-plaintiff, in case of co-plaintiff, what would be the position if he say no, desires to repudiate the suit. Rule 14, improper or unreasonable suit. This rule again further provides the right to the minor sole plaintiff upon the majority to apply for dismissal of the suit instituted on his behalf on the ground that it was unreasonable or improper. In this instance too, the notice should be served to all the parties. The notice should be served to all the parties, and the court may order the payment of all the cost by the parties. So, this is for unreasonable kind of things, unreasonable and improper suits. Rules applicable to person of unsound mind. This is rule 15. This is specifically for person of unsound mind. State that all these rules from 1 to 14 except rule 2a, that is security amount, rule 2a. If you remember, and you can go through also rule 2 again, then you will come to know how except or this rule 2a, otherwise all 14 1 to 14 rules provide specifically for minors are also applicable to person of unsound mind. So, adjudged by the court, and it is also applicable in this case. They were not adjudged as a of sound mind, but after inquiry done by the court, it appears that they are suffering from mental infirmity, due to which they were unable to protect their interest. The provision also applied to those persons who have not been adjudged to be of unsound mind, but have been found to be incapable due to mental infirmity by the court on inquiry. The faculties of person of unsound mind require adjudication, and this was a material issue in the case of Tirtha Pradhan versus Balbhadra Pradhan, wherein the petition as a plaintiff had instituted issued in the trial court against this Pradhan, a man of 90 years of age, for partition of certain joint family property. So, this is all I mean this is in rule 15 ki how, what would be the position ki whether these rules what we have studied from 1 to 14, whether these rules are applicable to a person of sound mind, I mean person of unsound mind or not. So, this is also you have to keep specifically. So, again I will take you back, this is first one. So, what we have to see this one ki interest of minor or welfare of the minor, I mean the crux of this order 32 of CPC, suit by or minor a person of unsound mind. The crux you have to understand, the importance you have to understand ki why we have kept this procedure, I mean this order 32 in CPC. Without this you cannot file your matter before the court of law. If you are minor plaintiff, if you are minor defendant, so otherwise as per order 7 of CPC, this becomes your duty in the plaint itself. Without it you cannot protect the interest of minor. So, basically this thing, I mean you have to relate. If you understand the importance ki like what kind of thing can come within the purview of this legal matters which are against or for the minor, or which are against or for the interest of a person of unsound mind. So, this is what we have to understand, and who will be, I mean who is minor, this is also through definition you can come to know, and who will be next friend, who will be guardian, this is also I mean very much important. Ki who will be next friend, ki who is a person who is a man of majority, I mean who has attained the age of majority, who is a person of sound mind, and otherwise whose interest is also not affecting, whose interest is not affecting, interest is not affecting. For this you will see rule 5 and 6 almost around this one, interest is not affecting, interest is not affecting, this is the thing what you have to understand. Interest of next friend or guardian is not affecting or is against the interest of minor. This is what we interest is not affecting, this is the thing what I am telling you. There are few key words actually what you have to, interest of welfare of minor or welfare of unsound mind, welfare of minor or person of unsound mind, and interest of next friend or guardian. There must not be any clash between between these two parties or between these two people, minor as well as next friend, minor plaintiff and next friend, and minor defendant and guardian. So, interest, because anybody or a stranger, otherwise court can appoint, you people also can come ki okay, this would be my next friend, this would be my guardian, that is a different thing. But if court will finalize this thing out of the scrutiny, out of the questions, court can ask any question from the next friend, court can ask any question from the guardian ki okay, how your interest, why you want to protect the interest of this minor plaintiff, why you want to become the next friend, why you want to become the guardian, why you have become the guardian. So, what I am telling you ki out of this question, and court must not be silent spectator. If somebody is coming, suppose plaintiff is coming, I mean through minor, okay, this would be my next friend or this would be my guardian, then court must not be silent spectre. Court must ask this question from the guardian, from the next friend. What's your interest? Why you want to become the minor? Why didn't you protect the interest otherwise? So, all those things, because this is very serious. It is a question of assets of the minor, it is a question of claim, a heavy amount. This can be heavy amount of insurance, this can be heavy amount of compensation, this can be heavy amount of claim. So, it is not very, otherwise also the minor entire life is based on the decision, on this decision. If minor interest, I mean next friend interest is affecting or is malafide one, then this will affect the entire life of minor. He is innocent one, minor is innocent one. We should keep this human, I mean humanity, at least we should understand this, I mean importance of this one. These order 32 is very important and very crucial one. You cannot take it just okay, this is simple procedure, follow it, whether this is right or wrong, follow it. No, you cannot, you must be sensitive at that moment when minor plaintiff is coming before the court, and advocate must also be very much sincere when minor guardian, when minor plaintiff is there, because it is a question of life, it is a question of minor interest. And if there is no welfare of minor, then this decision should not be taken, or at least, I mean because it is a question of minor interest, so that must be considered by the court properly. Court must not give opportunity to anybody, okay, I mean just by, if somebody is spotting affidavit, no, I have no interest otherwise, or I have no malafide interest, or my interest is not against the minor interest. That is not enough. Some sort of questions should be asked from the minor, sort of, I mean next friend, sort of questions should be asked from the defendant. I have seen personally in number of cases all these things, how this kind of proceedings takes place. So, that will affect the minor. He is very innocent, minor plaintiff is very innocent. Somebody can say, some buaji will come, some chachaji, some relatives will come, and they will say, no, we have no problem with that. We will contest or we will work on behalf of the minor plaintiff, we will work on behalf of the minor guardian. That is not the thing, because everybody, what I have seen, everybody is running after money and everybody is just keeping this particular interest, whether minor is getting. So, in between also, after appointment also, there should be close scrutiny of the next friend or guardian, close scrutiny, close examination of the work, whether really he is working, whether really he is fit for this one. Today if he is somebody good, but tomorrow whether he will be good or not, who knows this one. Next friend, I am talking about next friend, I am talking about the role of next friend and guardian, because the party is minor, the party is of unsound mind. They are not knowing what is right for them, what is good for them, what is I mean really whether this is beneficial for them or not, this decision particularly beneficial for them or not. It is a question of their education, minor education, it is a question of their health, it is a question of their other personal issues. There are number of things which are coming day by day against minor, like sexual abuse of minor, or different, whether they get education, proper education or not, because somebody is working for them. Role of minor is just like a parent. If somebody is not having that kind of emotion, parent like emotions, if somebody is not having that kind of affection and love, then that should not be appointed as next friend or guardian. So, that is the reason these provisions from rule 1 to 14 and basically talking about okay, the appointment of guardian is very serious, the appointment of next friend, that is the reason they have kept provision also, the provision of retirement, the provision of removal in different rules, through which you will come to know that retirement and removal can also take place, because court is very much vigilant about it. And court must, I mean pay, even I will not expect this thing, even not only from me, but even the advocate must understand this one, because it is a very, this is not like other matters, like in case of what happens in otherwise those who are major one. So, serious, I mean serious consideration should be given to the appointment of guardian, serious consideration should be given to the appointment of next friend and the welfare of the child. This is the ultimate thing. So, through all these rules, like minor to be next friend, apart from it this without friend who will, and security to be furnished. This is for, again, I mean, the court must get deposit this security amount also from the next friend. These are the few things what we understand through this one. So, who may act as next friend or guardian, this is who may act as next friend or guardian. There is a clear provision in through rules, you will understand in order 32 of CPC. So, welfare of child and interest, welfare and interest of minor, as well as the appointment of guardian, who will be fit person to be appointed as guardian and next friend for minor as well as a person of unsound mind. So, these provisions along with order section 11 of Contract Act or section 32 of your Indian Partnership Act, as well as in Limitation Act also from section 6, 7 and 8, basically providing sort of limitation to minor. So, all those provisions you should club, and accordingly as well as section 118 of Indian Evidence Act, you should club and you should read this thing and then read order 32 of CPC. You will come to know more about it and you will get more clarification on this point, okay, what is the importance of this procedure, because this is for the welfare of the child. This is all about order 32. Thanks.